This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance Report. Today I'm thrilled to have back with me Mike DeBernardis. Mike is a partner at Hughes Hubbard, and Mike and I get together after the end of each quarter to take a look back at some of the key enforcement actions, issues, pronouncements, and other matters that have come to fore over the past quarter. We take a look at the YPP, FCPA enforcement action, and a little bit on Credit Suisse, the monitorship issue raised by John Carlin, pronouncements from the SEC, the National Security Directive, and the Pandora Papers. I know you will enjoy this episode. This is Tom Fox, back for another episode, and today I have with me back again Mike DeBernardis, partner at Hughes Hubbard and fan favorite for our quarterly wrap-up, where we take a look back at the last quarter. Mike, as we did in the first two quarters of 2021, it may appear things were not a lot was happening, but it turns out when we pull the covers back, there was a heck of a lot happening. We had a couple of FCPA cases, one of which was WPP. Credit Suisse just came down in early Q4, so we're going to talk about those as well. Both had some pretty detailed fact patterns that have been explored on lots of other pods and blogs. So what I really wanted to ask you about both of these cases is they seem to me to have lots of lessons learned for both the white-collar defense professional, the corporate compliance program, and the compliance professional. So maybe if I could start off by asking you, what did you think some of the key lessons are, or more appropriately, what are you and your Hughes Hubbard's colleagues talking to your client base about in the context of both of these enforcement actions?
Yeah, and I guess let me first say I'm happy to finally be on here and able to talk about some meat, some actual FCPA action. So I agree with you completely. I think there's some really interesting lessons coming from both of these cases, and at the same time they're very different. For WPP. We've been using this really as an example for our clients of the risks around M&A, because in this case you had a situation where WPP was expanding aggressively in international markets and acquiring many smaller firms, and then really leaving those firms to operate as they had been before, just under the WPP umbrella. One of the things we often tell our clients is, you obviously, when you're doing some acquisition activity, you want to be careful about what that company has done in the past, so that you're not sort of purchasing an FCPA issue. But one of the bigger things is that moment that the deal closes, they're now working for you. They are part of your company, and so any misconduct from that moment forward is on you. And it seems that was a message that was maybe lost on WPP, and they failed to put in place controls to deal with the increasing risk that they were getting themselves involved in. The other thing that sort of stood out to me about WPP, and it's a good example of, historically when I first started doing this, oil and gas companies were concerned about the FCPA, maybe some defense contractors. But the broader other industries maybe thought that this was a problem that they didn't have to think about. And I think over the last few years, we've really seen that there's no industry that's immune from FCPA enforcement. WPP is an advertising firm. We've seen retail, we've seen software. Microsoft had issues. We've seen beverage companies. There really is not an industry that is going to be immune from FCPA issues. If you were out there operating in the international space, you are exposed. Credit Suisse is a much different case, and I think the lessons are a little more nuanced there. I think it confirms a lot of what we've been telling clients for the last several years: increased international cooperation. Right? Especially these bigger cases. They're almost always going to involve multiple agencies from multiple countries, and Credit Suisse involved the U.S., obviously, the U.K. and Swiss authorities. it's a good example of I think what's a growing trend of I like to call it mixed misconduct, right? So we had FCPA issues that were resolved, we had fraud issues that were resolved, and we're sort of seeing this, especially for the more complex cases, come up more, and it really shows a increased cooperation internally within the agencies here in the U.S. and working across different units to make sure you're capturing all the misconduct involved. And then, I think anytime I see where a company does not receive full cooperation credit, sort of an alarm goes off for me, because there's an opportunity to learn what matters to the DOJ. And so Credit Suisse, I think, received 15% off of the bottom of the U.S. sentencing guidelines, where they were eligible for up to 25%. And at least in the press release, the statement was that 10% was due to some delayed responses in places. But I'm always alert to those situations, because you can really learn a lot when you see what the DOJ is giving cooperation credit for and what they're withholding credit about.
So, Mike, let me follow up on a couple of points from both cases, and let me just start directly with Credit Suisse, because I really liked your thoughts on the mixed misconduct, and maybe I want to take it a little bit different direction, because there seemed to me to be two major types of red flags from really two separate but related transactions. The first one was the original tuna bond deal. And clearly there were red flags around the individuals being utilized as third-party intermediaries and the payment schemes. But the thing that perhaps interested me even more was the second deal, which was when it became clear that the original bond offering was not going to be repaid. They repackaged those and made them essentially sovereign debt of Mozambique. And then they sold that to investors in a huge fraud, which I think more directly impacted Credit Suisse. And I wanted to focus on the second transaction, because one of the things I've been trying to communicate is the deal itself can be a red flag. And perhaps the best example is Goldman Sachs on the Malaysian case, where they were getting, I think, $300 million for floating a $6 billion bond far above market. And here we had essentially payment terms far above market. And Credit Suisse was the one that was repaid on the backs of the bond investors. Do you ever really counsel people to look at the overall transaction? I don't want to use the phrase, if it's too good to be true, it's not true. But it seems to me that looking at actually the entirety of the transaction could lead to at least asking some questions. Is that something you guys counsel your clients on?
Yeah, for sure. And the comparison, I think, to Goldman Sachs and the 1MDB case is a good one. When I first read this about the Credit Suisse case, my initial thought was this is sort of a mini version of the 1MDB issue in some ways. But your point is really well taken. I think it applies broadly, because what we often counsel clients on when they're doing due diligence, whether it's on a deal, whether it's on a potential contract with the customer, whether it's on a contract with a third party, is first look at it from a business standpoint. Is there a business justification for it? Do the terms make sense from a business standpoint? Things like you mentioned, are the terms too favorable, really too good to be true? All of those things are a signal that maybe you need to look a little deeper into what is going on here. So I think that's absolutely right. This is perhaps a really obvious example of it, and to the extreme, but it really applies sort of down the chain to transactions that are occurring every day.
So now let me turn to WPP and another thing that really intrigued me about that case, and it's what I'm going to call perverse compensation incentives. And this is, at least the way I define it, where a compensation scheme or plan that you and I would look at and say, routine, we've certainly seen this before, it's incorporated into a lot of different comp programs really becomes perverse. And the best example there is Wells Fargo with their sales program. But here we had the entities that were purchased, the owners who were acquired by WPP had earnout provisions. And that's one of the most ubiquitous provisions in any M&A deal. You want the owners, you want the key employees to stick around to help with the transition, but also to help make sure that the subsidiary is profitable. How do you help a client really think through or watch or put an internal control in place to prevent what you and I would consider an appropriate compensation incentive from becoming perverse?
We're going to have a quick word, and then we'll be right back with more from Mike DeBernardis.
Yeah. I guess first, I think we might need to get a trademark lawyer on here and start trademarking some of these terms we're coming up with here. But I think there's a middle ground here. So I think WPP part of why it's so interesting is it seems very extreme. Not only did you have these perverse, as you term them, perverse compensation agreements or incentives, but then you had absolutely no control on top of it, right? You're right. The type, in general, the type of incentive that was set up, where you want to keep these executives on board for a transition period to really keep the business moving, are very common. And I think if you had packaged what WPP had done from a business standpoint with actual compliance controls on top, so monitoring what they were doing, making sure that when they're using third parties, they were going through due diligence, all of those types of things, it might have been fine. But what you had was these very aggressive compensation incentives, so that these executives really had an incentive to boom the business as much as they could, and you had really no control over what they were doing. No really ability to monitor what they were doing. I mean, they were in a lot of these places. The entities that were being acquired were basically acquired and then left to do business as they wished, with very little supervision. So I think there's a way to marry those two things. And when we're talking to clients about incentives, whether maybe it's sales incentives for business development folks around the world, or incentives for third parties that you're engaging, there's always a combination of the two, right? It's always a sliding scale. You can have aggressive incentives because you want to motivate your people to do the work, but the more aggressive you go, sort of the stricter the controls you need to have in place to monitor what they're doing and make sure they're not doing anything inappropriate to sort of achieve their goal.
So let me turn to another area that I would like to maybe highlight around WPP, and that was broadly the whistleblower reporting, the original investigation, and then the final investigation. And in India, we had a whistleblower who was very diligent. He had 7 separate whistleblowing reports, and there was an original investigation by apparently a non-investigative accounting firm, which was very limited in scope. And what I'd like your thoughts on, Mike, are why when you have I had a friend that said when you have a serious problem, you have to have a serious, good law firm investigating it. And you've done lots of investigations, and Hughes Hubbard has done lots of investigations. And I think part of the reason your success is your credibility with the regulators. But I'd like to focus more on the investigation. And why is it critical if something comes in, it gets properly triaged and reported up, that you bring in a seriously good investigative firm who knows the basic questions to ask, and more importantly, knows the follow-up questions? Could you maybe focus on why the need for a top-notch investigative firm is called for when you have something like this?
Yeah, this is a really good example of it. I think this is a good case study for the need for this. So I think there's sometimes a perception, and some of our clients have it initially, that anybody can do an investigation. right? Oh, we can do this ourselves. We'll send the manager from China out to investigate, or we'll send whoever it is. We'll send our internal auditor out to do the investigation. The reality is, I think a good investigation involves obviously the ability to get to the facts at issue, but it's also the ability to understand what facts are going to be relevant, to understand the legal implication of certain facts as you're learning them, to know where to follow up and where to not follow up. And then you're right, there is a degree of credibility that firms have with the regulators that is useful. But there's also the experience and the diligence that good investigative teams use ensures that you're not stuck in a place like WPP or some other examples of this as well, where the first investigation doesn't get to the crux of the matter, and now you're doing a follow-up, and now things maybe have compounded and have gotten worse. Or in a worst case scenario, you make your presentation to the regulator and say, hey, here's all the facts, and then you find out months later that you missed key facts, and the investigators didn't speak to the right people, or missed key documents, or missed key issues, and you're left sort of going back to the regulator to sort of explain that mistake. So it really is critical, and there's skill involved there. I think that sometimes people who are less experienced with having to investigate things don't appreciate.
To turn to another area that we had some very interesting comments, and that came from a DOJ, I think an assistant attorney general, John Carlin. And the thing that intrigued me about his remarks, I don't want to say it was the standard, but we're going to aggressively investigate. We're going to take people to trial. But at the end, he said, we're going to take a very hard look at whether companies are fulfilling their obligations they agree to under a DPA and NPA or any other type of agreement. And that struck me as perhaps there might be a change in philosophy at this Department of Justice around the use of monitors. Obviously, the Benchikowski memo was an expression of the prior administration's thoughts around monitors, and many of us followed that. But the WPP case seemed to me to be based upon what we know from the public record in terms of the cooperation and the problems WPP had, not even having a compliance function up to 2017, that this was a case that would have been appropriate for a monitor to be appointed to make sure WPP followed their agreements. We've also had a recent announcement by the DOJ they may be revisiting a current DPA in place. And so it seemed to me WPP might be a transition case, because I suspect most of the settlement was done under the prior administration and certainly before the new leadership team came into place. Really, any thoughts on Carlin's remarks and that part of WPP, and that the Department of Justice may be more closely scrutinizing companies after the settlements are signed?
That's for when Carlin gave his speech. I think across the industry, the part of it that got the most attention was this comment that there's going to be a surge of resources towards corporate enforcement, and the FBI unit is going to be embedded in the fraud section. But similar to you, I actually found this last sort of comment towards the end of the speech about the way that they're going to monitor and really scrutinize DPAs and NPAs to be really interesting. It was to me at least, listening to the speech, reading the speech, it struck me as very purposeful. It wasn't just you can say the surge in resources and we're going to enforce aggressively, as you would expect that in any speech. There seemed to be a clear message being sent with that comment. One of the more remarkable things in the last 2 years to me is the lack of monitorships. I think we're about 2 years. It's been about 2 years almost since the last time a monitor was imposed in an FCPA case, which is really just considering where the trends were and where we are now, really pretty remarkable. When the Biden administration came in, it was one of the things that we pointed to as a potential change in approach, because they had really been used successfully in the past to monitor companies. And I do think that these comments by Carlin are a signal that's in play. So whether WPP is a transition case, and whether the very next one will involve a monitor, I don't know. But I do expect, as this administration continues into 2022 and beyond, monitorships will again become a more commonly used tool. And aside from that, I think that there's the monitor really is often focused specifically on their compliance program of the company and making sure they're meeting those obligations. I think the comments by John Carlin suggest that the DOJ is also going to look very closely to make sure that any cooperation obligations the company have are carefully followed, and that might mean, are you providing the information on the employees as you promised you would, and they're serious about potentially pulling a DPA or an MPA if the company balks.
So let me turn now, Mike, to the Securities and Exchange Commission. They've had some very interesting remarks from Chairman Gensler on down, but we had one series of remarks by the Director of Enforcement around increased enforcement, and most interestingly, or differently perhaps, admissions of liability in settlement documents. If we accept that the SEC and DOJ always telegraph the moves they're going to make in advance, do you really see the admissions of liability in settlement documents as something that could become a real thing?
We've heard this before, so I'm not discounting that this is going to happen. But there has been noise around this issue in the past. I think there's a lot of industry groups that think that these no admit, no deny settlements are letting the companies off too easily, and that the SEC should insist on an admission. I think it's be careful what you ask for type situation for the SEC here. There is, I personally believe, in dealing with clients in these situations, that the requirement to admit certain allegations will lead companies and individuals both to be more likely to fight. I think if and maybe that's exactly what the enforcement division is going for. We should stop letting companies off easily, and if we really think that they have committed certain conduct, they either have to admit it or we have to prove it. But I do think that could be an end result if they take this path. I think the no admit, no deny is an important piece for SEC settlements in particular. I just think that there are a lot of collateral consequences that come from admitting certain misconduct, and that the consequences are such that companies will be willing to fight allegations as much as they needed to avoid that admission.
Mike, one of the things that's interested me, I just did a series looking back on the Delaware Supreme Court and Caremark, and their really expansion of Caremark duties in shareholder derivative actions. And it struck me in reading the remarks about potential admissions and liability that could be a very powerful tool in civil shareholder litigation in state courts, typically Delaware, perhaps other courts as well, and that it could lead to, could sort of roll in on itself and lead to further expansion of Caremark if you have companies admitting defects in the forms of admissions in SEC orders as well, increasing the cost in a wide variety of related litigation.
Exactly. I think that's one piece of exactly what I'm getting at. The add-on effect to admission. It's not as simple as we don't want to admit that we did this because it looks bad. There's legal liability consequences, I think, that flow from that are really serious for a company. And so I think frankly, a lot of SEC settled enforcement actions result from this ability to do a no admit, no deny, and pay your fine and take your lump and sort of move on and have that be the end of it. If instead the consequences are going to be years of potential liability, whether it's derivative securities, there could be potential criminal liability. Who knows? It really changes the calculus in doing that settlement.
So this is our third podcast of this year since we just finished Q3. But in each podcast, I've been able to say one of the most ubiquitous phrases in the corporate world in 2021 has been ESG, and that continued in Q3. The SEC has talked about climate disclosures. They've talked about ESG disclosures. Are we any closer, or I guess I should say, are you and your colleagues any closer to being able to give some advice you feel comfortable that the regulators are giving on what ESG disclosure should be, other than just get it right?
Yeah, it is. I think constantly evolving at this point. And you're absolutely right. I think we've talked about this maybe on each podcast so far this year. It continues to be one of the top 2 or 3 items that we receive questions about. Right now, I think the best advice we have is make sure you're getting it right. Make sure it's accurate. Because right now the focus of the SEC, at least on the few cases that they've taken so far, have been on inaccurate descriptions of ESG activities, misrepresentations regarding certain activities, and I think all of that's with the understanding that the investing public is more and more interested in this and is putting more and more weight into what companies are doing in this space. And when you have sort of that materiality involved, it increases the burden on the companies to make sure they're being really accurate with how they're describing this stuff. And so that's the best advice we can give, and we're continuing to monitor really what the SEC is doing and the types of cases it's bringing to see if there's other issues and other compliance aspects that the companies need to be concerned with.
So this next question was meant to deal with Q3 SEC issues around crypto and SPACs, but we had 2 events this week that I thought really crystallized where we might be on both of those issues. And on the SPAC, we had WeWork go public via a SPAC, and lots of howls by people about WeWork's culture, obviously, the last time they tried to go public, and where the new management team, has it really been able to turn it around? And more importantly, have they put the appropriate SOX 404 controls in place? And then the SEC's, I'm not sure how you would characterize their relationship with crypto and cryptocurrency, but we had a coder company this week who has delivered subpoenas turn around and sue the SEC. Strikes me as one of the ways to piss the SEC off is to sue them over subpoenas. Nevertheless, this coder felt the need to do so. Do we have any further clarity on those issues that you have seen, or how are you helping any of your clients work through those issues from the SEC perspective?
So, those are very different things, but in some ways, I think they're similar in that it's a place where I think the SEC and regulators more broadly recognize there's a problem. They just haven't quite figured out how to fix it. Everybody across the board is talking about crypto, whether it's the DOJ, the SEC. I mean, the OFAC is talking about crypto in the sanctions space. But how do we regulate it? How do we control it? And what are we exactly enforcing? And so, from the SEC's perspective, it's been most often enforcing it in connection with offerings. The make sure there's no fraud in crypto offerings and that type of thing. For the DOJ, I think they're looking at it from more of a money laundering standpoint. With SPACs, it's the same thing. I think there's a recognition that this is a bit like the Wild West here. How do we, from the Division of Enforcement, what are we doing? How are we enforcing it? in similar ways to ESG, I think what they're left with right now is disclosures, and making sure that the registration statements are accurate, because these SPACs, it's happening really fast. There's a huge amount of activity, and I think that there is perhaps in some cases a little less care given to the disclosures made about the target company and its activities and that sort of thing that might happen in a traditional IPO. And so really focusing on those issues to, one, to make sure that the investing public is receiving accurate information before they're putting their money in. And two, I think that the effort is to sort of maybe try to slow it down just a bit to make sure everything happens with a little bit more care. I think both of these areas are continuing to evolve, and we haven't quite landed where we ultimately will with in terms of the regulation and the enforcement. And I probably we probably won't land there until some type of regulation is passed specifically related to these items, and the DOJ and the SEC can step in and enforce that law. So right now they're using the tools they have to try to regulate it as best as possible.
We had two releases of major papers through journalist outlets. One was Facebook, but I'm going to leave that one to maybe our Q4 wrap up because I want to see a little bit more how that plays out. But we had the Pandora Papers, and these followed on from the Panama Papers and the Paradise Papers. And most of the discussion in the media was around, politicians or foreign government officials who were using trust or other vehicles to make money opaque, whether it was for nefarious reasons or whether it was for legitimate tax avoidance reasons. Nevertheless, what I wanted to do, Mike, is see if you thought the release of that papers in terms of its timing might really influence what the Department of Treasury, FinCEN, or others are doing in writing the regs around to enforce the AML law of 2020. And does this really heighten the need for increased transparency from the regulatory perspective?
It does. It does heighten the need for sure. I'm not convinced that this is, I'm certain that this is a problem without an easy solution. One of the, I think, for the general public, one of the more surprising aspects of the Pandora Papers was how it exposed that, this is not necessarily all offshore activity, right? I think that we have in our mind the Cayman Islands and some of these other places that are historically have been tax havens and had the secrecy. But, I think South Dakota has a growing number of opaque, the laws that allow some opaque ownership and less transparency. And, this is something that was pointed out. I don't know if you read the book Moneyland by Oliver Bullough, but it really drove this point home. The solution is probably, honestly, because this is such a global international problem, the solution that comes in with Treasury and others in, I think, changing the way that these funds can ultimately be used. So in regulating, for instance, we've had some changes in how the art market is dealing with, accepting funds from these accounts and these entities without knowing the ownership. You have, same thing with antiquities or real estate, because if you limit what these officials or wealthy individuals can do with the funds in these entities that have opaque ownership, you really can limit their use. And so I think that's probably what will end up being the solution that has the most impact. Because until you have that, I think you're always going to find somewhere, and this is how it came up in Jersey and Cayman, that sees the offering of corporate structures that allow for the hiding beneficial interests as a way to generate tax revenue for their location. And so assuming that some of those locations clean up their act, and I shouldn't frame it that way, but change their laws, there's just going to be another location that steps into their place. So I think the solution really is going to come from how these funds are used, and that puts pressure, frankly, on our clients operating in those spaces to make sure they're paying close attention to any new regulations that are passed regarding dealing with offshore entities or entities without knowing the ultimate beneficial owners.
Mike, we have talked about the Biden administration National Security Directive, which came out, I believe, in April, which identified corruption as a national security interest. And President Biden directed multiple U.S. government agencies to find ways to fulfill that directive and enjoin the fight against corruption simply beyond the Department of Justice and the Securities and Exchange Commission. That report is due out at some point in December. And what I really wanted to ask was, since corruption has been identified, I've had several people ask me, will the U.S. move to more robustly enshrine the whistleblowing process that started largely with Dodd-Frank, which has been a huge success for the SEC, and move that same program across multiple government agencies? Or is that something you guys have thought about or are thinking about at Hughes Hubbard?
I think that could ultimately be one of the things, certainly, that comes out of this. I think this is going to be a long process, so I don't expect the results that we December. I think there's a report is expected. I don't expect that to have all the answers. I think that a whistleblower, a more embracing the whistleblower model, could be one thing that comes out of it. I think efforts by individual agencies within the U.S. In their own space to combat corruption could come out of this. So, if you look at the defense sector, maybe some additional diligence before, providing military support or weapons to a foreign government. If you look at things like USAID, some additional anti-corruption resources there to make sure the projects that are being funded are not affected by corruption. I think that's a likely product. And then what I really think it's going to be felt, at least in the short term, is perhaps a change of focus of enforcement. And so we saw this a little bit actually with John Carlins' comments, where he said we're going to focus on corruption, anti-corruption enforcement in Latin America, and particularly places that are the home to many of the immigrants that are crossing the U.S. border. And so sort of using the fight against corruption to tackle specific problems we have back home, I think will be the most immediate effect of these studies and the interagency review.
Mike, unfortunately, we're nearing the end of our time for this podcast, but I wanted to maybe turn to the upcoming Hughes Hubbard FCPA alert, ask you if you had an idea when we might expect it this year, so what some of the highlights might be, or if you're participating in it, what are you looking at?
Yeah, for sure. Thanks for the plug. It's last year, because of the pandemic, we sort of got off schedule. We had typically done a sort of autumn to autumn schedule with release in early December. We're back on that this year, so you should expect the electronic version to be available. I think the first week of December is what we're shooting for, with the nicely bound hard copies to come shortly after that. It hasn't been our 2020 alert there was like 25 FCPA enforcement actions that we studied. It hasn't been that type of year, but there's been a lot that's gone on around the world, and so like usual, we've got a robust discussion of what happened in France and what's going on in Brazil and China and other places where there is activity, and we know from talking to clients and other companies that there's interest in learning more. I guess one thing to look for is we have each year we sort of use it as a theme, a quote from a whether it's a musician or an actor or someone who's passed away, and this year we've used a quote from Omar Little from The Wire, in remembrance of Michael K. Williams, the actor. So be on the lookout for that. I won't give any more information than that, but that'll be it works well. Let's put it that way. And it's really, we have a big team that puts a lot of time and effort into it. So it's shaping up to be another good resource this year.
Well, we will look forward to it. It's always the first one of the season, so it's incredibly well read and incredibly well written. I look forward to it. Mike, it's always a great pleasure to sit down and visit with you, and I look forward to our Q4 wrap-up.
Yeah, thanks for having me, Tom. Good to talk to you.
This is Tom Fox again. I hope you've enjoyed this special two-part podcast series where I interviewed Matt Silverman. We took a deep dive into trade and export compliance. We premiered a couple of new podcasts on the Compliance Podcast Network in October. Karsten Tams and I take a look at design thinking and how this social engineering tool can be used by a compliance professional. And on a passion project, I'm doing the Hill Country podcast. In our initial episode, I visit with Kathy Ragsdale, the matriarch of Camp Stewart for Boys, located just outside of Hunt, Texas. So check out these podcasts along with the 70 other podcasts now appearing on the Compliance Podcast Network.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.